Well, it's another week in January and another day to break down the administration of criminal justice law 2017. First of all, this is Wheel of Justice. And if today is your first time tuning into the program, it is designed to help you understand the administration of criminal justice law 2017 and also helps you know how the law helps to speed up the dispensation of justice. This program is brought to you by the Acjl State Administration of Criminal Justice Monitoring Committee and Prisoners Rehabilitation and Welfare Action Power with the support of the Open Society Initiative for West Africa, OSIWA, and the Acjl State Justice Reform Team. Now, this week we will be looking at the warrants of arrest under the sections 35 to 42 of the Acjl 2017. Now, many persons do not understand when an arrest warrant is needed to carry out an arrest. Also, many do not know what things that should be contained in a warrant of arrest. Now, most if you show some persons a warrant of arrest, they do not know what it looks like or what should be in it to make it official. Well, we're talking about this, and I have with me His Worship Chuks Nwankpa, who is the Chief Magistrate Grade 2, sitting at Umuahia Chief Magistrate Court and also presiding magistrate here. He's going to helping me better break this down in a way we can all understand it. So when we'll come back, I'll start my discussion with him. And don't forget, you can also, ask your questions. And in case you want to know more about the warrant of arrest, you have the opportunity to do that later on the show. One more time, welcome. And this is Wheel of Justice. All right, welcome back. Wheel of Justice comes your way Tuesdays from 3:30 p.m. and my name is Ifeanyi Awa. Well, back to my guest for today. As I told you earlier, I will be speaking with His Worship Chuks Nwankpa, who is the Chief Magistrate Grade 2, sitting at Umuahia Chief Magistrate Court and presiding magistrate here. I want to say welcome to our studios.
Thank you very much.
All right, now let's start off with the issue of warrant of arrest. It's not a new term to a lot of folks, but for better understanding, let us start off from that point. What is a warrant of arrest?
Okay, just as you have said, to lay persons or lay minds, they may find it somehow difficult to appreciate or to understand what a warrant of an arrest is. But to we, the legal minds, and considering what the law has said, the term or the word warrant, simply just to make it simpler for people to understand, is a kind of an order issuing from the courts. Normally it is issued from the courts, directed to persons, certain persons or categories of persons, such as the law enforcement agencies like the police, to apprehend certain persons who must have contravened the law, and who somehow finds it difficult to answer to a summons by the courts. And secondly, too, it could be seen as an order also directed to certain degree of law offender and law enforcement agencies, directing the apprehension of certain persons who must have disobeyed an order of a court duly issued.
All right. So, when can a warrant of arrest be issued, or majorly, how does it work?
Like I have said, from the little definition I've profiled, I said it is usually issued from a court when there are one thing. If someone is alleged to have committed an offense and he neglects to answer to maybe an invitation from police authorities or other security agencies, in a bid to cause his appearance, which is proven to be difficult somehow, a court an application could be made to the court for the issuance of same. In other words, there must be one neglect of observance of an order of a court, and or maybe commission or contravention of an alleged offense.
Now, sometimes we see police officers arrest without a warrant.
Yes.
And maybe based on what we see in movies, and sometimes you just want to say that did they come with a warrant of arrest?
Yes.
The question is, does an warrant of arrest come up for every offense, or is there a level of offense before a warrant of arrest can be issued?
Yes, by the provisions of the law, certain degree of categories of offenses, if committed by an offender or a suspect, can only be that's the production or the presence of the person or attachment of the person could only be had upon and production or issuance of a warrant of arrest. Such offenses like we say there are indictable offenses or offenses that are felonious, and then those ones.
Let's break it down. Felonious, indictable.
Yeah.
What are they?
Yeah. For instance, you have offenses we call misdemeanor. Those are simple offenses of which maybe the jail terms or punishments is below something like 6 months and worse. But then from 1 year, 2 years upwards, then you could categorize them as felonious offenses and indictable offenses.
Okay, now I want to break this further.
Yeah. If the alleged offenses or contraventions are in the categories of being felonious, you cannot arrest that person without being armed with an issuance of a production of a warrant of arrest.
Okay, now it means for you to arrest someone who has committed a felony, you need a warrant of arrest.
Yes.
Now let's know what a felony is and misdemeanor. For example, would you say stealing? Is it a felony?
Stealing, yeah.
It's a felony.
Yeah, because I had already provided a definition. I said offenses, there are the simple offenses and then felonious offenses.
You know, a lot of our listeners might not understand the felony and the misdemeanor, because you said the term those who have lower jail term, and we do not know how the judicial system gives out the jail terms.
If you look at, for instance, now as we have the administration of criminal justice law is a kind of procedural law.
Okay.
Then you have the law that stipulates the offenses and the appropriate jail terms. We have that as our criminal code. That is the criminal code law of Abia State. It provides for offenses and the jail terms. Now, looking at each, assuming one is alleged to have committed an offense of stealing.
Okay.
If you look at another section, I think 383 of the criminal code law, and going forward, you will now read through and see the number of years the person is to serve as a punishment. It is provided that the person, upon conviction, if you find him guilty, he is to be jailed for 3 years. So, assuming it is for 3 years upwards, then you can now begin to talk about offenses that are felonious.
Okay.
If the offenses are below 1 year, you talk about 6 months, 1 month, all those kind of things, misdemeanor and simple offenses.
All right. Now let's move in because of time. Okay. A warrant, going through the law.
Yep.
It says that a warrant of arrest can be issued on any day,
yes,
including the public holiday and Sunday.
Yes.
And I know that courts do not usually are not usually on Sundays and on public holidays.
Yes.
So does that mean that it has to go to the judge's house to get this warrant of arrest, or how does that work?
I think it said under section where are we? So yes, because what it means is this: by section 38 of the Acjl 2017 of Abia State, it said a warrant of arrest may be issued on any day, including a Sunday, on a public holiday.
Yeah.
I think simply put, that suffices. Wherever the judge, we simply say, we used to say that wherever a judge, the court is sitting there. Assuming you accost a judge, maybe in his vehicle or maybe in his house, subject to the provisions of this law now. I think the warrant of arrest, if it is issued on a Sunday or even on a public, it is valid. But however, by convention now, by convention, one could not be, maybe on a Sunday, you go to a judge or a magistrate to begin to disturb him to issue a warrant. I think by convention, we try to put that aside. But if it is very, very imperative, that warrant should be obtained on that day for the purposes of achieving the aim for which it is applied for, Sunday, public holiday, is a valid day to issue. Doesn't matter.
Okay. Now, if you're just tuning in, I'm speaking with His Worship Chuks Nwangba, who is a Chief Magistrate Grade 2, sitting at Umuahia Chief Magistrate Court, presiding magistrate here also. And we're talking about the issue of the warrant of arrest under the Acjl. And so far, he's been breaking down the things around the warrant of arrest and how it should be issued. So we got to have some more questions to ask pertaining to how it can be carried out, and also the role of the offender who the warrant is meant for. But you have to do just stay tuned. When I come back after this very short break, we'll get back to that. And don't forget, if you love to ask questions pertaining to a warrant of arrest, he's right here to also answer you and break it down for you in the way you can understand it. Numbers are 0808 182 6949 or 0811 605 2949. Again, 0808 182 6949 or 0811 605 2949. You can send an SMS to 0906 510 8289. This is Will of Justice. It's exactly 15 minutes before the end of the show, but let's go back to our discussion. We're looking at the warrants of arrest under the sections 35 to 42 of the Administration of Criminal Justice Law 2017. And my name is Ifani Awa. I'm speaking with His Worship Chuks Nwangba, who is a Chief Magistrate Grade 2, sitting at Umuahia Chief Magistrate Court, and is a presiding magistrate here. Now, let's go to I want to take a part from section 40, subsection 1, where if you permit me, I'll read it out. States, a court issuing a warrant of arrest may, where its immediate execution is necessary and no police officer is immediately available, direct it to some other person or persons, and the person or person shall execute same. Now my question comes to the other person or persons. Who are these other persons? What does it mean by these other persons? Do they mean civilians?
I don't think if you read they said subsection, I think subsection 1, you actually note that in the first place the primary persons who execute the services of a warrant of arrest on targeted persons is the police.
Yes.
But then where the police is not readily available, there are other sister security agencies. Like for instance, you have the civil defense, and the likes. These are the persons, because the court cannot direct a civilian, are you getting me, to go and execute its warrant. So where the police is not available as at that time, civil defense people can come into aid. Maybe all these other persons, like either the legions, some categories or degree of government recognized security agencies could effectuate that on behalf of the court. The court cannot direct an ordinary civilian to go and execute or serve a warrant of arrest on the targeted person.
Okay. Now let's go further to where the public summons says it says section 42 subsection 1A says in a newspaper. Let me start from this. Says a public summons shall be published in a newspaper that enjoys wide circulation or circulated in any other medium as may be appropriate. B says by affixing it to some conspicuous part of the house or premises, or to some conspicuous place in the town or village in which the person ordinarily resides. And C says by affixing a copy to some conspicuous part of the High Court or magistrates court building. Now, basically, it's gone from being just a warrant of arrest in the form of a letter to being a public summon. So when does it go from this stage to being a public summon?
Well, in other words, why there are exceptional situations and circumstances to every rule. That is,
May we know this exceptional situations?
In other words, it's like this now brings in with it certain exceptional circumstances. For instance, now, if you had issued a warrant, if a court had issued a warrant of arrest against someone, and the person is physically available and within the reach or territory of the courts, you understand? This simply means taking the warrant to the person and serve it on the person. The person is expected to kind of present himself before the court. But in this case now, where it is impracticable to access the person physically, then and there are information, evidence of the fact that he is within the area that's not visible.
When you say not visible, what do we
he cannot be reached. Okay. Actually, the person is evading or hiding. Okay. Are you getting me? That is where he is invisible now. That's invisible.
Okay.
Then the court can resort to giving the permission for it to be done in this manner, and it is deemed as a service notification.
Okay.
As a valid notification.
All right. Now, another question I want to ask is when the judge gives an arrest warrant in Nigeria, if he's giving an arrest, does it cover the whole of Nigeria?
It depends. It depends on the nature of the application. For instance, if it is an application that should have a wide effect, that is in terms of across the whole country, and the court is convinced on why such an order should be, that is, warrant should be issued. The court will issue such order and directs the appropriate persons to effectuate it in that manner. That is, it will have a wide range effect. That is, you understand? So what it means is that normally all the targeted stakeholders, like the targeted stakeholders like the security agencies in each of these shall be empaneled or empowered to execute that warrant wherever they see the suspects or the wanted person.
All right. Now, we'll go further in a bit because we're entering into the last minutes of the show. But first, we'll just take a very quick detour and we'll come back. We'll try to get some more understanding on this. And also, if you have calls to me, if you want to ask questions pertaining to a warrant of arrest, you also have the opportunity to do this. Justice right here. And don't forget that it is brought to you by the Abia State Administration of Criminal Justice Monitoring Committee and Prisoners Rehabilitation and Welfare Action Prawa, with the support of the Open Society Initiative for West Africa, OCWA, and the Abia State Justice Reform Team. I omitted this part earlier. Also with me in the house, I have Kelechi Imo, who is a regular in the house. He's representing Prawa right here, and he's always here with us, knowing how things are going. Now, we've been talking about the warrant of arrest, and I was speaking with His Worship Chuks Inwankwa, who is a Chief Magistrate Grade 2, sitting at Umaya Chief Magistrate Court, and presiding magistrate here also. Now, we're talking about breaking different angles to the warrant of arrest. Some persons say, should a warrant of arrest be issued for a particular offense or this and that, and he's tried to answer all those questions. I've got a few more minutes on the show, just in case you still have your questions. 0808 182 6949 or 0811 605 2949. You can send an SMS to 0906 510 8289. Okay, now let's, because we're almost done because of time. Why a warrant of arrest, just like I asked earlier, can be executed? He said it depends. When the judge gives a warrant of arrest, and I asked if it can cover every part of the country, he said it depends on. So let's explain that part again.
I had earlier said, for instance, the court jurisdiction, that is territorial jurisdiction, that's the area of exercising its powers geographically, is usually within the districts or within the states where the court is situated. But in this circumstance now, assuming that a suspect commits an offense or is being wanted in particular, for instance, Abia State, and he's nowhere to be found in Abia State, that is, he's invisible now, and all efforts to get at him is not yielding the result, the intended result. This should be the alternative measure. You issue a summon that will have a wide effect, that is wide range effect across the whole of the federation. And based on the circumstance, the court will grant that order for the person, that is the targeted stakeholder, that is the security agencies, to beam their searchlight in any parts of the federation or country and to make sure that the person is apprehended. So, what is important is that within the geographical limit or territory of the court issuing the warrant, if the person is not available, not visible, or he is hidden, or his information had reached to the authorities looking for him, that he had escaped into another territory, I think that is where the public, the warrant of arrest is issued to go outside the state of issue and to, exert the desired effect.
Is there a limit to a warrant of arrest? Is there a limit, a time limit?
No, there is no time limit for the validity of a warrant of arrest. Warrant of arrest, once issues, its validity continue to be in effect. Even the dates, the only circumstance, for instance, the dates or transfer of the magistrate or even the judge cannot stop it. Cannot stop the effect.
So the death?
Yes, I said the death.
Okay.
And the transfer or elevation of the issuing authority.
Sorry, if the magistrate dies, or maybe is transferred from that place, yes, or maybe it's promoted, yes, it wouldn't affect it.
Yes, except it is cancelled. Are you hearing me? Except it is cancelled by the issuing authority. So there is no time. There is no time limit for its effect, except cancelled.
All right, quickly. Hello. Good afternoon. What's your name?
Yeah, this is Chief. That is God from the Power for Autonomous Community of Imo State.
Okay, please go on with your question very quickly while running
out of time. Good afternoon, Magistrate.
You're welcome.
Yeah, please, I want to know if the authority is required to arrest somebody's mother or father in the absence of the offender himself. Is it proper?
Okay, simply put, if you understand the language of the law, there is what we call vicarious liability. That is, in criminal trial. Are you hearing me?
No, God, he's listening.
Okay, so in criminal trial or anything pertaining to criminal issue, there is no vicarious liability, meaning that you cannot superintend the contravention or infraction or offense of another in place of the other. In other words, I have answered you now to the extent that you cannot use the allegation or offense of another to arrest another. So if it is done in that manner, it is illegal.
Okay, means you cannot arrest the parents, siblings, relations to someone who's wanted.
Yes, except there are elements of collusion or conspiracy. In other words,
they planned it or they knew what was happening.
Yes, but if those things are not inherent in the maybe circumstance, you cannot, because there is no vicarious liability in criminal trial.
Right. Thank you very much. Yes. This last part, maybe some other day would have time to discuss on this more, because I'm sure a lot of persons have cases on this. But I want to say thank you very much for coming. I'm speaking with His Worship Chuks E. Nwakpa, who is the Chief Magistrate Grade 2, sitting at Umuahia Chief Magistrate Court, presiding magistrate here. I want to say thank you very much for making our time to come explain this.
Thank you for having me.
All right. And this is what we have to call it today on Wheel of Justice. Do not forget, it comes your way Tuesdays from 3:30 and is brought to you by the Abia State Administration of Criminal Justice Monitoring Committee and Prisoners Rehabilitation and Welfare Action Power, with the support of the Open Society Initiative for West Africa, OCWA, and the Abia State Justice Reform Team. Thank you very much, Kelechi, for always being here. Kelechi is always observing. I call him the Observer Team on behalf of Prawa. Thank you very much. All right, my name remains Ifeanyi. Keep listening. There's more to come right here. You got to do is stay tuned. Bye for now.